Welcome to Immigration USA Update. Today, we bring you a shocking update about U.S. green card travel changes taking effect on December, and every immigrant must know this. We are witnessing one of the most aggressive shifts in immigration enforcement in recent history, and if you are a green card holder planning to travel this winter, you need to pay close attention immediately. Just days ago, on December 2, 2025, U.S. Citizenship and Immigration Services, USCIS, released a critical policy memorandum that fundamentally alters how permanent residents from specific regions are processed and vetted. This is not just a minor bureaucratic shuffle, it is an immediate, adjudicative hold and a comprehensive re-review of approved benefits that could leave thousands of travelers stranded or facing deportation proceedings upon their return. The administration has cited national security concerns following recent tragic events involving National Guard troops, and the fallout is a massive tightening of borders. For many of you, the green card has always been a symbol of safety and permanent status, but this new directive challenges that assumption. If you leave the United States right now, especially if you are from one of the 19 identified, high-risk, countries or have a pending application, you are walking into a minefield of new scrutiny. This video will break down exactly what the December memo says, which countries are on the list, and why simply holding a green card might not be enough to guarantee your re-entry this holiday season. The core of this shock update revolves around the new list of 19 countries subject to extreme vetting and an immediate pause on benefit processing. According to the December 2 directive, USCIS is pausing all pending applications and initiating a re-review of already approved green cards for individuals who entered the United States on or after January 20, 2021, from nations including Afghanistan, Venezuela, Haiti, Iran, and several others. This is the critical travel change you must understand. Typically, a green card holder returning to the U.S. is not treated as an applicant for admission unless they have triggered specific legal conditions, such as being away for more than 180 days or having a criminal record. However, with this new re-review policy active, Customs and Border Protection, CBP, officers at airports have been given broader discretion to treat returning residents from these regions as if they are seeking new entry. This means that even if you have a valid 10-year green card, your status is effectively under investigation the moment you present it at the border. We are already receiving reports of travelers being pulled into secondary inspection, having their phones and digital devices searched, and facing grueling questions about their original asylum claims or visa applications. The government is looking for any discrepancy, any small error in your past paperwork, to justify revoking your status under these new national security protocols. Let's look at a realistic scenario to understand how this impacts you directly. Imagine a green card holder named Mateo, who is originally from Venezuela but has been a lawful permanent resident, LPR, for 2 years. He decides to visit family in Europe for 3 weeks over the holidays. Under normal circumstances, his return to the U.S. would be a formality, a quick scan of the green card and a welcome home. But under the December 2025 guidelines, because Venezuela is on the high-risk list and Mateo received his residency after January 2021, his file is flagged in the system. When he lands at JFK Airport, he isn't waved through. Instead, the CBP officer sees a review pending notification linked to the new USCIS memo. Mateo is taken to a windowless room for 4 hours. Officers are not just asking about his trip, they are re-adjudicating his entire history. They ask why he moved, who paid for his visa, and whether he has maintained ties to his home country, ties that could contradict his original claim of fearing persecution. Because he is physically at the border requesting entry, the burden of proof shifts back to him. If the officers are not satisfied, or if the hold on his nationality category prevents them from clearing him, Mateo could be paroled into the U.S. for a deferred inspection or, in a worst-case scenario, placed in expedited removal proceedings. This is the terrifying reality of the travel change. Your re-entry is no longer guaranteed by the card in your pocket, it is contingent on passing a brand new security check that didn't exist when you left. It is crucial to understand that this scrutiny is not limited solely to the 19 listed countries. The ripple effects are causing delays and heightened caution for all green card holders. The December directive has diverted massive amounts of USCIS and CBP manpower toward these security reviews, meaning standard processing at ports of entry is slower and more aggressive for everyone. If you have been outside the United States for more than 6 months, even by a single day, you are now in a danger zone. The law states that an absence of more than 180 days automatically makes you an applicant for admission, stripping you of some of the protections usually afforded to permanent residents. In the current climate, officers are enforcing this rule with zero tolerance. We have seen cases where residents returning after 7 months are accused of abandoning their residence. They are being asked to prove they still live in the U.S. by showing recent utility bills, tax returns, and employment records right there at the airport. If you cannot produce this evidence on the spot, you risk having your green card confiscated and being issued a notice to appear in immigration court. The travel change here is a shift in attitude. The border is no longer a welcome mat for residents, it is an enforcement checkpoint designed to filter out anyone who has weakened their ties to the United States. For those of you holding conditional green cards, the 2-year cards often given through marriage, the stakes are even higher this December. If your I-751 petition to remove conditions is pending, or if you are traveling with an extension letter, the I-797 notice, you must be extremely cautious. The USCIS memo explicitly mentions a pause on adjudications for the affected nationalities, which includes I-751 petitions. This creates a legal gray area for travelers. If you travel abroad with an extension letter, and while you are away, the government pauses processing on your case or issues a request for evidence, RFE, that you aren't home to receive, you could find yourself stranded. Furthermore, airline personnel are becoming increasingly hesitant to board passengers with extension letters or wet ink stamps because they are confused by the rapid policy changes. We strongly advise that if you are a conditional resident, especially one with a pending case, you should treat international travel as a non-essential luxury that you cannot afford right now. The risk of being denied boarding in a foreign country because an airline agent misinterprets the new December ban news is simply too high. You might have the legal right to return, but if the airline refuses to let you on the plane, that legal right is useless to you in that moment. Here is the practical, step-by-step advice you need to follow to protect yourself and your family during this volatile period. First and foremost, if you are from one of the 19 countries listed in the December 2nd memo, including Afghanistan, Burma, Haiti, Iran, Venezuela, and others, do not travel internationally. This is not the time to take a risk. The re-review of your approved status means your green card is effectively in a probationary state until USCIS completes its security sweep. If you absolutely must travel for a life-or-death emergency, you must consult with a qualified immigration attorney before you buy a ticket. For all other green card holders, if you are traveling, you must carry more than just your passport and green card. You should travel with a Proof of Residence folder. This folder should contain copies of your most recent U.S. tax returns, a letter from your employer stating you are expected back at work on a specific date, and a copy of your lease or mortgage statement. This evidence preempts the officer's suspicion that you have abandoned your U.S. home. Additionally, clean your digital footprint. While you have rights, giving an officer a reason to snoop through your phone by acting nervous or having controversial content visible can escalate a routine stop into a nightmare. Be polite, be brief, and answer only what is asked. Finally, we need to talk about the moral of this situation and the key message you should take away from this update. The immigration landscape in the United States is shifting beneath our feet, and the era of set it and forget it for green cards is over. The December 2025 updates prove that permanent residency is a privilege that requires constant vigilance to maintain. You cannot assume that the rules which applied yesterday will apply tomorrow. The government is utilizing every tool in the Immigration and Nationality Act to reassess who gets to stay, and travel is the #1 trigger for these reassessments. Staying informed is no longer optional, it is a survival mechanism. Do not rely on rumors from friends or outdated advice from forums. The official policy memos are black and white, and they are being enforced immediately. Your priority must be to protect your status by staying on U.S. soil until this wave of re-reviews and processing pauses stabilizes. It is better to miss a holiday vacation than to lose the life you have built in America. If you found this video helpful, please make sure to like this video, subscribe to our channel, and share it with your friends and family. Thank you.